I allocated 15 minutes, so again, because I know Israel. I'm truly, as most of you can see, very excited to open this two-day-long conference celebrating the 30th anniversary of the Convention on the Rights of the Child. 2 months ago, I took on the role of Dean of the law school here at the College of Law and Science. And I see it as very meaningful that the first big event here at the law school with which I start my deanship is a conference that celebrates children's rights. Choosing children's rights as your field of work, devoting your career to children's rights is not like any other choice of field of interest. It is not just a choice of area of expertise. It says something about you as a person, about each and every one of you that sit here. In The Little Prince, Antoine de Saint-Exupéry wrote, "All grown-ups were once children, but only few of them remember it." I think that each and every one of you remembers. Making it your professional habit to think through the prism of a child, to ask the child question, makes you remember. And I think that all of us here are fortunate to remember, because remembering the child you were and maintaining true respect for children affects who you are, how you are as a family member, how you are as a friend, and how you are as a colleague. And I see many friends, colleagues here, and I'm sure I will make new friends, colleagues here during this conference. We have a rich, very diverse program, different topics, different jurisdictions, scholars at varying stages of their careers, and practitioners. And even now, before we start, I want to thank you all for making a contribution to this conference. And now indeed I reached the thank you part of my short introduction, and it is with great pleasure that I thank the quite long list of people who assisted me in organizing this conference. First of all, to my colleagues, Professor Anna Schoz, not only my co-convener, but a true partner to all child-focused initiatives here at the law school. We were joint directors of the Center for the Rights of the Child, joint editors of the Family-in-Law Law Journal. So we make many things together, and I want to thank you. To my wonderful colleagues from the law school, Professor Pamela Laufer-Yukelis and Dr. Tehila Be'eri-Alon. To my colleagues from outside the law school, Dr. Tamar Morag, who you will soon hear, Advocate Lydia Rabinovich, the head of Child Representation Program at the Ministry of Justice, who gave birth 3 weeks ago, but nevertheless will join us tomorrow. Yes, I want to thank our academic partners, Haruv Institute and the International Society of Family Law. You can find information about them in the folders. To our supporter families, I want to thank the president of the college, Professor Aviada Cohen, who will also join us tomorrow, and the general manager, Hudi Lieberman. Big thank you to our administrative staff. You met some of them outside. Karen Priva, Noah Lenzner, to Miri Yesharim, the logistic department here, Yoram Avraham, Evgeny Yakubovich here with the camera, Yafit Reiter, and Kfir Gidan. Last but certainly not least, our truly amazing students, Galit Oz, Galit, wave please, and Yaron, you will meet him tomorrow. who answered all your emails, took care of every little detail. They are the people behind the crc30aniv@gmail.com. Yep. They are the ones. I wish us all an interesting, inspiring, and enjoyable 2 days, 3 days for those of you who will join us in Jerusalem. And now I want to give the floor to the panelists of our opening panel. The chair of the session, Judge retired Saviona Rotlevi, will introduce the panelists, but I want to introduce her for those of you who, if there is anyone in the room who do not know her. You cannot use the term children's rights in Israel without mentioning Judge Rotlevi. Judge Rotlevi was a judge in the District Juvenile Court in Tel Aviv, and then in the Tel Aviv Court, District Court. Her judgments are still the model for child-centered law. She was involved in establishing ELEM, the first organization in Israel to assist young people at risk or in distress, and she was also among the founders of the Council for Children in Care, a voluntary organization that protects the rights of children who have been removed from their homes by social welfare services. But most of all, Judge Rotlevi is known for being the chair of the committee for implementing the Convention on the Rights of the Child in the Israeli legal system, the Rotlevi Committee, a committee that was appointed by the Minister of Justice. You submitted 6 reports, right? Okay, 6 reports. And Judge Rotlevi continued, even after submitting the reports, she continued to follow up and advance the implementation of the recommendations, as I'm sure you will hear in the first session. So I invite Judge Rotlevi to chair this session.
Good morning to all of you. Well, thank you, Ayelet, for such an introduction. It is very exciting for me to be here today and to see so many experts in children's rights. When I started my career in the judiciary, first in the Juvenile Court in Tel Aviv in 1978. The discourse was about parents' rights and the responsibility of the state to intervene in order to protect children. As far as criminal law concerning juveniles, children had rights, but they were not represented by lawyers. The attitude towards them was based more on rehabilitation than punishment, more on need than on rights. In my first years on the bench, I felt that something is missing in our juvenile court system. Judges tended to ignore children's rights in order to get to the point and come to a solution. The best interest of the child had a different meaning and interpretation than what we refer to nowadays. This was before the Convention on the Rights of the Child. The Convention gradually changed the discourse. When I was appointed, as mentioned by Professor Blechel, when I was appointed in 1997 to chair the public committee for the implementation of the CRC into Israeli law, the atmosphere was changing. We had the cooperation of the government and later on the Knesset members, our parliament, and were able to come up with many recommendations in various areas relating to children and youth. I must admit that despite my optimism and vision, I did not expect such huge changes to occur in such a short time. And I'm very proud of that. And this could not happen without the help of 80 experts and a very devoted young staff. We still have a long way to go in order to achieve full absorption of the notion that children are human beings and right holders, not in the future, but now. As Janusz Korczak used to say, children are not the people of tomorrow, but the people of today. I believe that all of you who came here to participate in this conference share this view. I also hope that all of us take the responsibility not to forget the hundreds of millions of children and youth who have no rights in their own countries or in other places where they reside. Too many children in the world are being exploited, discriminated against, exposed to violence, are traded or abused from a very young age, and even forced to serve in the military at a very young age. Let alone children who live in poverty and cannot enjoy the basic right to life, survival, and development. We all know that we are in the midst of a very interesting worldwide process concerning children's rights, which comes at a time when the whole notion of the family is changing. I say a process and not a revolution, though many still consider children's rights as a revolutionary. I feel optimistic when I see the role that youngsters from different countries take upon themselves in changing the world. We see Malala Yousafzai of Afghanistan and Nadia Murad of Iraq, who are Nobel Prize laureates, and Greta Thunberg, who is now leading a crusade against the neglect of adults to keep the world safe and clean for future generations. These three youngsters can serve as the best example of the right to participation in a very broad and deep meaning. And this gives me hope for a better future. And I think it's a good start to start the panel. So I invite the three of you, right? Dr. Murad, Julia, and so with this optimistic view, we'll start the panel with great lectures on children's rights from three different places in the world. We have here representatives of Russia, South Africa, and Israel. So we start with Professor Olga Kazova. Professor Olga Kazova is currently affiliated with the Moscow School of Social and Economic Sciences and the National Research University Higher School of Economics in Moscow. Until summer 2018, for more than 30 years, Olga had been working as a legal scholar at the Institute of State and Law within Russian Academy of Sciences. She holds a PhD from that institute and LLM from Cornell University Law School, USA. She's a vice president of the International Society of Family Law. She's also a fellow of the International Academy of Family Lawyers. And also, Olga was elected as a member of the UN Committee on the Rights of the Child and was re-elected for the next term in 2016. She was a vice chair of the committee in 2017 and 18. We are all looking forward to your lecture. Yes, thank you so much.
Thank you so much. Dear friends, dear colleagues, let me first of all express my gratitude to the conveners of the conference for inviting me, and most importantly for giving me the floor the first thing in the morning. It's a great honor and also great responsibility. Thank you so much. Less than a month ago, we celebrated the 30th anniversary of the UN Convention on the Rights of the Child, or CRC, known as the most comprehensive, holistic, and inclusive international instrument on protection of children's rights. Celebrations took place in Geneva, in New York, and many other cities around the world. And celebrations continue because this is the main reason why we all are here. And certainly there is a lot of reasons to be proud of our convention. If we look back 30 years ago and compare where we were at that time and where we are now with regard to protection of children's rights, I'm sure you will agree that the progress made is tremendous indeed. The years of application of the CRC brought significant improvements in the lives of millions of children. But what is also important, and what I would like especially highlight, that the years of application of the CRC have significantly contributed to the perception of the child as an autonomous rights holder and brought tremendous changes in how we understand the role of children in social life. Indeed, for many people to acknowledge that a child is not a subject, that the child is not property of his or her parents, but an autonomous subject, required a very serious change in the mindset. I'm wondering if the CRC drafters actually fully realized what changes in our understanding of children and their rights this new philosophy will require. What would it actually mean to take children's rights seriously, and what the state parties would be expected to do to fully implement the Convention's provisions. With all my personal dislike of the word revolution, adoption of the Convention with its notions of best interests of the child, child evolving capacities, the child rights to have a say, was a revolution indeed. And Judge Rotley also mentioned this word, revolution, which is absolutely true. However, it is still one of the most serious challenges for many people, whether they are parents or governmental officials, to accept that a child, irrespective of the age, is a rights holder. Is a rights holder to the same extent as they are, and that the child has the right to express his or her opinion on all matters that concern the child to the same extent that we adults do with regard to issues of our own concern. That evolving capacities should not be interpreted the opposite way and seen because of the child's immaturity as an excuse for restriction of children's autonomy and self-expression. Thus, despite huge improvements in the lives of children throughout the world for the last 30 years, there is still a lot to be done. Indeed, countries are different with regard to protection of children's rights. Some are at the forefront, others are rather lagging behind. I'm sorry for this expression. But all in all, there is no country in the world that could claim that it has fully implemented the provisions of the Convention. And challenges continue, and they exist for all countries without any exceptions. There are so many problems with regard to children. Children are too often left behind. Among issues I would mention poverty, discrimination, criminalization, violence, and conflict are just few examples where children suffer serious causes, serious damages. Regrettably, despite all the progress achieved, children, as I said, are too often left behind. Therefore, implementation of the CRC is still work in progress for all countries and for all of us as we work on children's rights. Moreover, there are worrying signs that some of the gains for children achieved under the Convention are at risk of stagnation and even reversal in a few cases, as was rightly noted in a most recent UNICEF publication just literally published this November. Let's take vaccination of children as an example. Once, one of the greatest successes of public health that saved millions of children's lives over recent time has somehow stalled. The results are devastating. It's enough just to have a look at what's going on now in the Pacific region, where many countries, including Samoa, are in the middle of a measles epidemic, which came from New Zealand. This is a clear sign that some additional extra efforts are required to overcome this failure back with regard to certain aspects of children's rights. It's time for a renewed commitment to the Convention and to the children of the world, as UNICEF suggests. It's a great pleasure for me to know that the Committee on the Rights of the Child, in line with the UNICEF calling, but absolutely independently, while getting prepared to the 30th anniversary events, asked the states to renew their commitment by pledging to take one specific and measurable action for the promotion, protection, and realization of children's rights. 51 states sent their pledges to Geneva, and Israel was among them. All the pledges with the names of the states were displayed at Les Nations, where anniversary events took place recently. Another question, as to the question that I have been assigned to answer, how to ensure wider implementation of the CRC, I'm afraid I do not have a precise and clear answer. It's a lot of work consisting of very different activities, actions, and strategies. It's a process that has many different dimensions and directions and involves many different actors, and it assumes a lot of thorough thinking through. Nevertheless, if to try to sort out all these different things that are necessary to pursue this goal, the following should be particularly noted. So to start with the committee's concluding observations. The concluding observations is a document where the committee, while performing its monitoring function, directly addresses a particular state party on the whole range of issues related to children's rights. It is adopted as a result of a constructive dialogue with a particular state party. In all concluding observations, there is a part titled General Measures of Implementation, where the committee explains what is missing and gives certain recommendations that are necessary to ensure proper implementation of the Convention. To summarize the main issues raised in this part in different concluding observations, I would highlight the following. Firstly, it is important to have legislation, and based on it, governmental decrees and other regulations that set up legal framework for children's rights. It is necessary to ensure their adequate protection. While there has been certain increase in legislation to children's rights recently, sadly, in many countries, the law on children's rights remain very limited. If there is no national legal regulation that incorporates the provision of the Convention, it's very difficult, if possible at all, to speak about implementation of the Convention. So this is definitely the something that should be looked at very carefully. Secondly, it is absolutely important to have policies, strategies, action plans in order to have a clear picture on what specifically should be done, how it should be done, in what sequence, and who will be responsible for realization of all these strategies, plans, and policies. The experience shows that effectively functioning interdepartmental and multidisciplinary bodies which ensure cooperation of all the actors on the rights of the child is usually one of the keys to success. No doubt, and this is the third point that should be noted, all these measures should be supported by allocation of appropriate resources, both financial and technical and human. It is equally important to structure budgets in a way that would make allocation for realization of children's rights transparent, clearly identifiable, and traceable. It is also important to have properly functioning monitoring and impact assessment procedures that would allow to understand where the money goes, whether it is efficiently spent, whether it brings any results, and if yes, what specifically. I meet other necessary conditions for effective implementation of the Convention, particularly such as data collection that should be in place, national human rights institutions, civil society. All these and other issues are usually reflected in almost all, sorry, I'm doing something wrong, as always. Shall I test something? Oh no, it's better now. Oh, it's okay. And as the fourth point, I should specifically highlight education, which is not necessarily reflected in the part of general measures of implementation, but is absolutely crucial for better implementation of the Convention. This includes not only dissemination of the Convention itself, concluding observations and general comments. Dissemination should not be understood just technically. It should be accompanied by, for children, by specialized children's rights courses as a mandatory curriculum, and for those professionals who work with and for children, by regular training seminars on how the Convention should be understood and applied. This is often also a problem. At the same time, to make everything that I have just mentioned work, political will is necessary. And this is also what is often lacking. To make progress, children's rights should be at the political agenda indeed. And again, it's not always the case. I do hope that this 30th anniversary event will be an important contribution in this regard. A few words should be said about the structure of the concluding observations. Specifically, I would like to draw your attention to an innovation in the structure that was introduced recently at the request of the states and the NGOs. This innovation aims to make it easier to deal with the committee's recommendations. Thus, it was decided to give some guidance to the states on how to approach the committee's recommendation and to highlight the main areas of concerns with regard to a state party under consideration. It is a special paragraph titled Main Areas of Concern and Recommendation in the very beginning of the concluding observations, where the committee addresses the issues with regard to which urgent measures must be taken. So these are the most burning questions for this particular country. A few words about general comments. As most of you probably know, the main focus of a general comment is either a specific article or a specific theme, as for instance, street children or rights of adolescents is the most recent examples of the general comments. General comments set up the standards, particularly based on the committee's experience in monitoring the implementation of the convention by the state parties. They serve as the guidelines on how it is better and more efficiently to implement the convention in a particular area. The general comments are considered as a committee's jurisprudence, and it is expected that the state should follow them. Perhaps I'm wrong, but I have the impression that general comments are underestimated and not paid proper attention to. Some people are even not aware about their existence, so there is certainly a lot of room for improvement. Now I will move to what may be called or classified as the third way, how the committee can address the state parties, or rather a particular state party on a particular issue. This is an individual communication procedure under the third optional protocol on individual communications, where the committee responses to a concrete complaint regarding violation of certain article or articles of the convention or two other protocols. This optional protocol, or OPIC, as we call it for brief, came into force in 2014. Currently, it has 46 ratifications and 18 signatories. To date, there are over 100 registered cases, and the issues raised in these communications concern migration-related issues, child abduction, custody, visitation rights, surrogacy, juvenile justice, corporal punishment, and even male circumcision. The most significant portion of the cases received so far has been linked to the mass influx of migrants into Europe. They include issues related to non-refoulement, age determination, administrative detention of migrant children, separation of children from parents, family reunification, and access to asylum proceedings. If a committee finds a violation of one of the articles of the convention, it also reminds the state party, dependently on the circumstances and the context, that the state party is under an obligation to do everything necessary to prevent similar violations in the future. It's a pleasure for me to say that although not always, but quite often, the states do take measures in accordance with the committee's views. The document that the committee issues is called views. What is lacking in the work of the committee? Probably we may say that many things are lacking, but most importantly, in our committee, we do not have a follow-up procedure that would allow us to request a kind of an interim report on what has been done between the dialogues, what progress has been achieved, if any. In the committee, we are of the opinion that it would be very efficient if one or two committee members could go to the particular state country and discuss with the authorities the progress achieved, the obstacles they have, and also, of course, meet with the NGOs and other stakeholders in children's rights area. But regrettably, there is no money for that, and it's a pity. I'm sure you will agree with me. Anyway, on a more positive note, child participation. Child participation is becoming more and more topical issue now, and the children's rights to have a say on all matters that affect the child under the Article 12 is increasingly at the agenda. Interestingly, while the state parties are thinking how to take children's rights seriously, children themselves have started or tried to exercise their rights more and more actively. But even more interestingly, they claim their rights in the areas that the states may find very challenging to address. It's a new phenomenon, no doubt. For a few examples, children as human rights defenders We had an amazing day of general discussion last year, and child participation was really impressive. Children participating in political protest. We have clearly seen it in Hong Kong, Russia, and Egypt. Children requiring the right to vote, and they've got it in Austria and Greece, and at the local level in Scotland and in some other countries. And the most recent example, children claiming the state parties to the convention to be liable for the climate change. We have registered in the committee a complaint from these active children. I don't know what we will do with that. Thus, participation of children is growing. Children are increasingly making their governments to reconsider the vision of children's rights. This brings us hope, at least as it seems to me, that the child's rights movement is at the turn of a qualitative shift, perhaps to a significant extent thanks to children themselves. And the last point. The life is not still. Things are constantly developing, and new things bring new challenges, including for those of us who work in protection of children's rights and implementation of the convention. I will give you two examples. Protection of children across the borders is increasingly at the agenda. The convention, to repeat, known as the most comprehensive, holistic, and inclusive international rights instruments, covers also very different issues that arise when children or their parents or caregivers cross the state borders. During the recent time, due to globalization processes, due to increase in number of mixed marriages and unions, due to increase number of mixed marriages and unions, and accordingly the number of cross-border disputes, due to tremendously increased migration, the respective articles of the convention are becoming increasingly important. I would like to draw your attention to children who cross the state borders as migrants, as who are refugee or seeking refugee status, and who are too often unaccompanied and separated from their families. According to the statistical data published by UNICEF last year, of all children who arrived to Europe last year, a total of 12,700 children were unaccompanied or separated, what constituted 42% of all children that arrived, so it's slightly less than a half. It's a huge national problem, it's a huge problem for many states, it's a huge international problem, and there is no adequate solution so far. Can any state solve such problem alone? I doubt. In our globalized time, there should be joint efforts and strong international cooperation. Joint efforts of the states, joint efforts of treaty bodies, NGOs, all of us. Another example that I have promised to give you in connection with the new developments and new challenges relates to digital world, and that will certainly require joint efforts. Can any state alone solve problems related to our children living online? I doubt. Taking into account the transnational nature of the digital environment and of the networks, services, and businesses that underpin it, international cooperation is absolutely vital to effective protection of children's rights in this area. The committee has started to work on a draft of general comment on children's rights in relation to digital environment, and to anticipate, this will be definitely one of the recommendation to the states in this general comment. Hopefully it will be adopted, although it's not an easy document. Do I have 2 minutes to conclude? To conclude, I would like to come back to what I said in the beginning, to children as autonomous rights holders. It's not easy to treat children as equals. It requires many different qualities and skills. The most importantly, it requires respect for children and their rights. And this is also often is missing. I think Ailed mentioned this important, absolutely crucial point in success. In success in protection of children's rights. I would like to give you a few quotations from a book by Janusz Korczak, A Child's Right to Respect, first published in 28. I skip a bit. So, children need respect for their lack of knowledge, respect for the work acquiring knowledge, respect for failures and tears, respect for children's possessions and budgets, respect for the tears and doubts of the hard work of growing, respect for culture, for the current hour, for today, respect for each individual moment, for these will pass and never come again. The child's right to respect is not explicitly stipulated in the CRC, but it crosses the line of each and every single article. And it seems to me if there had been a better understanding and acceptance of the child's right to respect at very different levels, from parents to governmental officials, we would have certainly achieved better and wider implementation of the convention. Thank you so much.
Thank you so much for such a not only interesting but really deep understanding of the implementation, of the difficulties of the implementation of this. Thank you so much. And now Professor Julia Sloat-Nielsen. Pronounce it well? Yes. Okay. From the University of Western Cape, South Africa, and Leiden University of Belgium. Professor, can I call you Julia here? Okay, to be shorter. Julia is currently senior professor in the Faculty of Law at the University of the Western Cape. She also holds a chair in children's rights and in the developing world at Leiden University in the Netherlands. She served as Dean of the Faculty of Law of the University of the Western Cape from 1929 to 2013. A major research contribution has been in the broad field of children's rights, and she was a member of the South African Law Reform Commission Project Commission that drafted the Children Act at 2005 and the Child Justice Act from 2008. I'll skip something because it's very long and you really deserve it, but we don't have enough time. So I'll just, yeah. Her most recent publications include a child justice update of recent case law, a chapter on surrogacy in South Africa, and a chapter on children and informal justice systems in Africa, and a chapter on corporal punishment in South Africa. Well, lots of topics. Each of them deserve a separate discussion.
You need help with
Everybody, and as the previous speaker has already mentioned, I would also like to thank the organisers very much for the invitation to speak at the ISFL Regional Conference. It's my very first time in this region, and I'm very pleased to be here. Although I do follow some of the developments in Israel from time to time, such as the corporal punishment in the home debate, which we have just kind of resolved in South Africa, sort of, a couple of months ago. I have a rather daunting topic to speak of. Firstly, quite a long period of time, 30 years, and then secondly, to speak of a very vast geographical area, namely a whole continent. And I've taken the approach that I'll first give some facts and figures that I think might be of interest, and then talk a little bit more about continental issues, picking up on what my predecessor has said. Look at some of the challenges, which are probably all very well known to you, but bear repeating in the assessment of where we are after 30 years of the CRC. And I am looking at the convention in its most holistic scope, not just from the family law perspective, but also from the rights that are contained relating to health, relating to education, relating to child protection, Article 19, as well as juvenile justice to some extent. And then I will come to some more positive stories, and then I will conclude. So that is the introduction and structure. Just to contextualize, I served as a member of the African Committee of Experts on the Rights and the Welfare of the Child for 5 years, from 2011 to 2016. So I did, in that capacity, get a pretty good overview of the implementation of children's rights in countries outside of my own, sitting right at the south of the continent, South Africa. And I've also worked in many sub-Saharan African countries, including Namibia, Botswana, Kenya, South Sudan, Mozambique, Botswana, etc., etc. So I do have an idea of the implementation of the CRC in countries outside of my own as well. So, starting with some facts and figures, Africa's child population will reach 1 billion by 2055, making it the largest child population amongst all of the continents. From 2017 onwards, which is already 2 years ago, Sub-Saharan Africa is the region with the highest number of births, and no decline in population growth rates, and this trend will persist for the rest of the century. This is a justification for making it imperative to take Africa's children along the road of implementation of children's rights. Mortality rates among children under 5 decreased by 58% between 1990, the date on which the convention came into force, and 2017. And this can be largely ascribed, and I'll come back to this maybe if I remember, to the implementation of the Millennium Development Goals, the MDGs, which had as one of their indicators the reduction of infant and child mortality rates, which were achieved in a great many African countries by 2015. But still we have the problem that 5.4 million under 5 deaths in that year occurred in Africa, and these are largely preventable deaths. Child deaths tend to be concentrated at the youngest age group, with 85% of all deaths to children under 15 occurring amongst children younger than 5. And the preventable diseases that I refer to, pneumonia, malaria, and diarrhea, accounted for 36% of all under 5 deaths in Africa. So there's a long way to go towards implementing the rights contained in Article 24 of the CRC related to prevention of infant and child mortality. And on current trends, 31 million under 5 deaths will occur between 2018, last year already, and 2030. So as regards the implementation of health rights, the story is not yet over. As regards education, this was another key goal of the Millennium Development Goals, was to achieve universal primary education. However, the assessment of the MDGs showed that although this was achieved in many African countries, it was achieved at the expense of quality education. There was what was called access shock, so classrooms with hundreds of children, unqualified teachers, so that the focus of the next development goals, the SDGs, has to be on quality education, which also depends on well-trained teachers. 11 million new teachers will be needed by 2030 to meet this best sub-regional performers pupil-teacher ratio. And then just a few other points that I threw in here because I thought that they might be interesting and relevant. Africa is the fastest growing population in the Muslim regions of the world. By 2060, 37% of the population of sub-Saharan Africa will be Muslim. Now note that I talk specifically here of sub-Saharan Africa because we know that the Muslim majority is evident in North Africa, in countries such as Algeria, Morocco, Egypt, and Tunisia. So I'm only talking about the population of sub-Saharan Africa. And it is estimated, although I couldn't find a recent figure for this comes from work that I did some years ago, that 40% of children in Africa grow up under Islam. And there are implications on this for children's rights, as I will show in 2 screens' time, notably the fact that there have been reservations entered into the CRC by some countries on the basis that they will not recognize rights that they regard as incompatible with Islam. And there's also a link between cultural practices and beliefs under Islam, although not exclusively so. So that's a very incompetent rendering of a map of Africa. Unfortunately, for some reason, my Adobe Acrobat license expired last week, and I could no means of copying anything from Adobe Acrobat. So this is what we have, but it gives you a sense of the vastness of the continent and also the sense of regional specificities. I've just mentioned North Africa, in which the implementation of the CRC is very different, as well as the economic indicators, as is the case in, for instance, Central Africa, places like Central African Republic, Burundi, and Chad and Cameroon at the moment, which are mired in conflict. West Africa has its own set of dynamics. East Africa is growing from a point of view of economic development. And Southern Africa has various differing issues related to countries like Zambia, which is a highly indebted poor country, Zimbabwe, which is basically melted down completely, with all of the challenges that arise from that. Mention was made also, I think, of the stagnation, and I don't have a screen on this because it might get me into trouble, but one does have to look at political dynamics in the region. I was working last year with a certain Minister of Justice of a neighboring country who is now sitting in jail for corruption. This is not an unheard of story. He's actually a really nice guy. And I really thought he was going to implement my juvenile justice law really quickly, but now he's sitting in jail. He was arrested 2 weeks ago. The story of corruption is an ongoing one, which dilutes resources available for children, and as well as the story of mismanagement and incompetence in some quarters. Now, just to give an idea of the ratification status, Ghana was the very first country to ratify the CRC of all countries in the world in 1990. And sponsored and spurred on by UNICEF, there was universal African ratification quite quickly, with Somalia being the one exception, but Somalia has now ratified, I think it was in 2015.
There are, as I mentioned, a lot of countries that have entered reservations. I've listed a few there: Algeria, Djibouti, Egypt, Mauritania. But when Somalia ratified and entered the same kind of reservation, that it would not apply provisions it felt to be against Islam, there were a number of countries that did not accept that reservation, which I think is significant. Now, recently all the things that the opening speaker, Judge Ratlevi, mentioned were last year. This is this year. This year I worked on the publication Getting Girls Equal, which was launched on the 15th of November of this year. It is a report on the position of the girl in the law and policy in the whole of Africa, and I just put the cover on there for you. You can download it off the website of the African Child Policy Forum, ACPF, based in Addis Ababa. And I think it was a useful exercise to undertake to see how the position of the girl child has fared after 30 years. So some of the overall findings in this report, which covers a variety of domains, are firstly that great gains have been made in accessing primary education through the MDGs. But nevertheless, 23%, that's 1/4 almost, of all girls are out of school. And the dropout rate in secondary education is enormous. And primary education, useful though it is, doesn't get you to the next base, which is the ability to participate in the economy. The report also, drawing on other reports, notes the very high prevalence of sexual abuse in schools, as high as 83% in Botswana, 55% in Cameroon, and 50% in Rwanda. We know from the work done by organizations such as Girls Not Brides that 40% of girls in sub-Saharan Africa marry before the age of 18. Zambia, the figure is 42%, Malawi, it's 40%, and some countries it rises to 60 or 70%, like Niger. It has the highest adolescent pregnancy rates of 2018, which is also contributing to the huge growth of children. Children's numbers, for instance, 40% of children in Guinea are born to adolescents. There are some laws that discriminate directly against girls still in relation to inheritance, in relation to transmission of nationality, although the discrimination is more subtly evident in the actual indicators that one sees. So 1 in 10 girls misses school during menstruation, which means that 1 in 10 girls misses 20% of any given school year. Overall, girls are completely invisible in policy. We know that the CRC is, in its gender neutrality, does not highlight the situation of girls other than in relation to harmful cultural practices in Article 24. And the report also looks at intersectionality, the particularly vulnerable position of girls, not just as girls, but as girls in domestic work, girls in street situations, girls with a disability, girls as members of minority groups, etc., etc. Violence is another area that I think is a point of concern, as illustrated by the findings of the 2006 report of the Special Rapporteur on children against violence, and the subsequent work of Marta Santos Pius and her successor as Special Representative of the Secretary General. And there is increasingly documented data illustrating the prevalence of violence against children. So 33% of girls experience sexual violence before the age of 18 in Eswatini. If you don't know where Eswatini is, it's the new name the king gave to Swaziland. So you can just read for it, Swaziland. In Kenya, 2 million children are orphans. 1 in 3 girls have experienced sexual violence, and 73% of boys have experienced physical violence. Some communities in Kenya, 94% of girls have undergone FGM, or cutting. And then some more statistics there, and in the interest of time, I'll move on. Just one point about corporal punishment. The countries that have prohibited corporal punishment in all settings are provided for you on the screen, But that is not to say that corporal punishment doesn't actually occur in all settings, possibly outside of the judicial system, but certainly in schools, in homes, and in many other settings. And the point I always make is that in South Sudan, you don't smack your children, you just shoot them. So the banning of corporal punishment is in and of itself not nearly enough. Now, I've mentioned the role of armed conflict. 2016 was described by UNICEF as the worst year for children in Africa because of the outbreak of armed conflict in places. The African Committee of Experts commissioned a study, and this is taken from the press release of that study into armed conflict, focusing on North Africa, Libya, as you know, northern Kenya, where Al-Shabaab is operating, Nigeria, where Boko Haram is operating, and it does not make for pleasant reading as to the impact of armed conflict on children. And we're not only talking about children recruited into militias, but we're talking about children whose schools are burnt down, whose hospitals become unavailable, who lack access to healthcare and emergency services because of the armed conflict in their region. Harmful cultural practices. I want to just show you the following picture, which is it this picture, which I downloaded before my Adobe Acrobat license expired on Thursday. This is a picture of children being chained up. Now I need to go back. Okay, this was a picture of children being chained up in Senegal. The person who had effected this was a Quranic teacher. Children get sent to Quranic teachers in regions like West Africa to learn the Quran, but they actually get sent out onto the streets to beg. And then, as you can see, locked up, chained up. The person who did this was sentenced for 2 years imprisonment, as well as the blacksmith who made the chains. I wonder if I can go back. No. Thank you. Just to mention that this very issue was. Thank you. One more. This very issue was the subject matter of a communication to the African Committee of Experts against Senegal, the so-called Taliban case. And the committee has been having found against the government of Senegal for failing to address the issue of the children attending Quranic schools. The committee has been several times to Senegal to try and help government implement that decision, which was handed down in 2014. But obviously there are still many cases of this kind of abuse carried on. Harmful cultural practices. This is taken from Girls Not Brides and indicates the prevalence of child marriage in the region. And as you can see, Africa stands quite high in the world, and there are many countries where child marriage is extremely prevalent, as I've already mentioned. I would like to reflect very quickly, because I think my time is expiring, on the role of HIV. HIV was from around 1996, when it was realized that HIV was not only an epidemic affecting gay men, but that it was also one that had profound implications for children, both adolescent children and also newborn children who were acquiring HIV through the birth process. This led to a huge volume of research, conferences, medical research, research on sexual and reproductive health behaviors, which I'm sure many of you are all aware with. And it had a profound effect for a while on children's rights as well. So there was talk of the orphan generation. There was an expansion of alternative care, so-called orphan industrial complex, on the basis that all children in Africa were AIDS orphans. And it had enormous consequences for children's rights. And I've mentioned the field of inter-country adoption. We know that there was a huge rise in inter-country adoption from African countries. Ethiopia became the hotspot. And there's also been enormous consequences for voluntourism, that is, people going to volunteer to work in orphanages to help all the little kids there. However, new infections and child deaths have greatly diminished due to robust clinical work in the primary healthcare sector, and I would argue that HIV is no longer the threat that it once was. But on the other hand, Olga has referred to vaccinations. There are other huge risks, for instance, Ebola, malaria, measles, and I heard a paper last week on Ebola that's broken out in the DRC, which has killed X number of tens of thousands of children, but at the same time has also destroyed the capacity of the government to deliver on inoculations. And so the number of deaths from measles are even higher because the children haven't been vaccinated. Migration has already been mentioned, in particular migration to Europe, but one must also bear in mind that there's significant migration of children from the east part of Africa to the Middle East. There is significant migration in West Africa, both north to Europe and also within West Africa. And then from Ethiopia and Somalia downwards, there's migration to South Africa. And at one stage before the European crisis, South Africa had the highest number of refugee and asylum seekers in the world, one little country. So this is both an opportunity as well as a threat. We know that children are migrating for economic opportunities. They are migrating independently by choice, and this is nothing new in the history of the world. And one must look at ways to support children's independent choices to move and see where they can make a better life for themselves elsewhere in the world. Okay, now I come to some better news. So, as has been pointed out, there's been significant law reform in almost every country in Africa, which has been based on the CRC and is rights-based. Mostly it is aimed at creating a child protection system of the kind that you would be familiar with, so how to respond to child abuse and neglect, how to deal with children in alternative care. And for the most part, there's also been juvenile justice reform, although this is slightly more sporadic. Sometimes it's in the same statute, other times it's a separate statute. There's also been significant sectoral and issue-based law reform in the areas of trafficking in persons, in the areas of gender-based violence, domestic violence, prohibition of harmful cultural practices. So one can't only go and look at the children's law or the child protection statute. We are seeing increasing constitutionalization of children's rights. I could talk for 2 hours about South Africa, which constitutionalized children's rights in 1996. But we have Zimbabwe 2013 with some key decisions on corporal punishment and child marriage. Kenya also constitutionalized children's rights in 2010. Tanzania, very recent decision on child marriage. And also Malawi, and there probably are other examples in languages that I can't read. The role of the African Child Policy Forum has been significant in trying to track the harmonization of laws in Africa with the CRC and other international treaties. So it's worthwhile visiting their website. The question of systems strengthening for child protection was the topic of the general comment number 5 of the African Committee of Experts. The system strengthening approach comes from basically Save the Children in an attempt to respond to the silo approaches where you have one organization dealing with street children and one organization dealing with trafficked children and another organization dealing with abused children, and actually they should all be pooling their efforts towards the same system. And it attempts to secure systems building from the bottom up, from the community level up, rather than having some office at the national level trying to sort out what's happening out there in the villages and in the townships. It's strongly linked to a movement that started in 2010 about social workforce strengthening, because without a social workforce, which you would know as social workers or community workers, actually there is no child protection system at all. When I started working in Mozambique, 2003, population of 17 million people, there were 4 social workers in the country. 4. That's for the disabled, the elderly, people with mental health issues, children, you name it, 4 social workers. You can't do anything with that. Child participation has been mentioned and access to justice, as well as my publication of last year for the African Child Policy Forum on this precise issue. The publication covers all aspects of children's contact with justice systems, civil, criminal, and administrative, and it points to great improvements in, for instance, legal aid schemes for children in juvenile justice reform, in NGOs providing legal services to help children get their matters before court, strategic litigation, which is now taking off in the countries mentioned. So this is quite an encouraging story, although there's a long way to go. Specialized institutions have been developed in the 30 years of the CRC, for instance, dedicated children's courts, now more than 30 in Kenya, but in many cases they are limited to the capital city only. Dedicated specialized police units to respond to gender-based violence are also quite commonplace. I've given only 2 examples. And some places now have specialized forensic centers for data collection, for evidence collection in rape cases, so as to ensure more successful prosecutions. And the model is the Tutuzela centers in South Africa, which have also been rolled out in places like Zanzibar, Tanzania, and Malawi. There has been a huge decline in inter-country adoption from Africa, mainly due to moratoria from DRC, from Ethiopia, from Ghana. But as a paper I presented earlier this year attempts to show, there seems to be an increase in services offering international surrogacy. So that is also a place to watch in the future. And this is in the absence, with one exception, my own country, of any legal regulation of surrogacy at all. Very important are the cash transfer schemes that have been fostered by UNICEF, the World Bank, and DFID to reduce extreme poverty, and these clearly impact children in very positive ways, including access to education and to health. So this comes from the Sustainable Development Goals agenda, okay, rather than from the CRC itself, although, of course, the CRC does provide for children's rights to access social security. Other relevant treaties: slow ratification of the complaints mechanism, but widespread ratification of the African Children's Charter. I've mentioned the general comments of the African Committee of Experts. There's also widespread ratification of the ILO Worst Forms of Child Labour Convention and of the Paloma Protocol dealing with trafficking. There's a steady increase in ratifications of the Inter-Country Adoption Convention, but little take-up of the Abduction Convention. Very little take-up, and very little interest seemingly either. On the monitoring and enforcement level, there are any number of newish ministries and executive agencies, national committees for children. There's been good reporting to the CRC and the African Committee of Experts by African countries. There are now NHRIs, National Human Rights Institutions, in almost all countries with varying resources and capacity and independence, but no examples other than Mauritius of an ombudsman for children specifically. And then skip the second to last bullet, but the last bullet, very important, is the rise in importance of non-state actors, charities, international development agencies, and businesses and private sector agencies providing, for instance, private education and early childhood development facilities. Conclusions. See, I got there. Reconfiguration of the family. I know I'm speaking at the Family Law Conference. I venture to suggest that in many places, because of the very rapid urbanization that is occurring, and urban planners told me a couple of weeks ago that in some places it's at the rate of 100,000 to 300,000 new people per annum. And with that kind of rapid urbanization and the growth of megacities like Cairo and Nairobi and Dakar and those other Nigerian places that I don't like going to, there is obviously going to be a reconfiguration of the family and a demise to some extent of the kinship structures of old. In a conservative political climate, we are seeing a huge pushback on sexual and reproductive rights of adolescents. We have many examples now from Tanzania where the president wants pregnant girls kicked out of school right now and has enacted legislation to ensure that that happens. It's not the only example. And that does not bode well for those facts I gave you right at the very beginning. The visibility of children has greatly increased via the incorporation of children's rights and also through the work of aid organizations and through UNICEF and the legislation. However, children still lack the capacity or ability to pursue remedies by themselves in courts. Mostly they can only do this with the assistance of a parent or guardian ad litem. Customary law and pluralist legal systems remain highly, highly relevant, including even in urban areas where they are being re-established because of the inaccessibility of the formal justice system. Restorative justice had a huge landing and following in many African countries in the 1990s, but implementation seems to have waned and interest seems to have been lost to a large extent. And I refer here to restorative justice in the criminal law, juvenile justice context, but also in child protection and also in other areas that would interest you. So I conclude there have been some gains from 30 years of the CRC, but there's a long way to go. Thank you.
Well, thank you so much for such a rich representation. I feel lucky. I always complain about the situation in Israel, and I feel so lucky. And I really wonder how you stay optimistic. But probably we saw kind of a process of a change, and it's a lot of work to do. Thank you so much. And now to the last lecturer, Dr. Tamar Murag. Well, I'm very excited because Tamar, I can say, was my right hand for many, many years in the community and afterwards and before. And I think that without your help, I couldn't go through this effort. And it's a time to thank you here. Dr. Tamar Murag is the academic director of the Child Advocacy Clinic at the Hebrew University Law School and lectures at the Hebrew University Faculty of Law and the College of Management Academic Studies. Holds an LLB from the Hebrew University Law School and LLM from American University at Washington College of Law, and an LLM and SJD from the University of Michigan Law School. And since I want to give her at the time, okay. Okay. Just a minute. She's the editor of Children's Rights. Okay. She served as the vice chair of the Israeli Legislative Committee appointed to reevaluate the entire body of Israeli child law in light of the UN Convention on the Rights of the Child. In this capacity, she chaired its legislative subcommittee on children and their families and on separate representation of children. And as I mentioned, she was the vice chair of the committee. And please, Tamar, it's your time. I lost the. What happened? What do I need to do?
That's fine. Okay. All right. Okay. Israel ratified the UN Convention on the Rights of the Child in 1991. At the time, it was not accompanied by any meaningful public discussion or debate. The ratification appeared at the time as mainly symbolic, a rhetorical affirmation of the obvious, our commitment to children. The realization that the Convention carries a transformative message and leads to deep changes in the way we think about children and act on matters affecting them actually came gradually. None of us expected real changes on the ground, and I'm old enough to remember the time of ratification. My presentation will address a significant change in Israeli law that has been tied to the Convention, but we'll also try to examine the scope and the limits of this change. I will confine myself to the Convention's influence on Israeli law, even though well beyond the law. Its effect can be discerned in the social discourse, the academic scholarship, and the day-to-day practice of so many professionals. I will divide my presentation into three parts. First, the big change, or the revolution, if you want to call it. Second, the limits of the change, trying to look through the convention's four guiding principles at the actual implementation of the convention. And last, I'll try to take stock and look forward. So let's start with the big change, the revolution. In order to understand the extent of the Convention's influence on Israeli law, it merits attention that a unique, as you already heard, a unique public committee was appointed in Israeli law in order to re-examine the entire body of Israeli child law in light of the CRC. The committee was chaired by Judge Savion Rotlevi. I served as the committee's vice chair. And the extensive work of this committee is, as far as I know, one of the most ambitious attempts of any legal system to promote the Convention's systematic implementation. The committee was appointed in 1998 and published in 2004 6 detailed reports. You see some of them here at the picture. What? No. 19? Okay, we had 6 years. That's my story. I know 6 years, 6 reports, sounds good. If I'm wrong, I'm wrong. We published 6 detailed reports. You see some of them here at the pictures, relating to the different spheres of children's lives. The committee's work created a platform for absorbing into Israeli law not only the articles of the Convention, but the extensive interpretive work of the UN Committee on the Rights of the Child. Its reports are consistently cited in the academic literature and in case law as the canonic interpretation of the Convention in Israel. I'm actually very happy, we're here on a critical note, but I'm very happy to share with you that although there is still a very long way until we reach full implementation of the committee's recommendations, extensive parts of the recommendations have in fact already been implemented. Sometimes we don't know. You work in the committees, you don't know what actually is going to come out of it. But actually a lot has come out of this committee. Some in the form of new comprehensive laws and legislative amendments, some of which I will be discussing later on, and some through the establishments of new bodies, such as an ombudsman for children in out-of-home placement, and a new unit you will be hearing about tomorrow for child representation, established within the Israeli legal aid system that actually brought about a huge increase in the number of appointments of lawyers for children. In examining the Convention's influence on Israeli law, it is almost impossible to separate the Convention's direct effect on Israeli law from its influence via the committee's recommendations. And I will be doing it shortly. together. I will be addressing them jointly. So where and how can we describe the Convention's remarkable influence on Israeli law? First of all, in the legislation. Several statutes allude to the Convention as their conceptual and normative basis. For example, the law on the rights of students states in Section 1, the purpose of this law is to set the principles for the right of students in the spirit of human dignity and of the UN International Convention on the Rights of the Child. The definition of the Convention as the starting point of this law and several other laws that actually refer to the Convention in the first declarative statement of the law is particularly significant, as it makes the Convention their central, normative, and interpretive source. Other statutes were extensively amended in light of the Convention. For example, a comprehensive amendment to the law on juvenile justice, which anchored a broad reform with regard to detention, interrogation, and punishment of delinquent youth, was based on the Rotlevy CRC report. The legislation that, in my view, expresses the most significant endorsement of the Convention is the 2016 Children's Foster Care Bill. This law, which was also based on the work of our committee, places children and their rights at the center and defines government actions on behalf of children in foster care through the lens of children's rights. Legislation dealing with children at risk had so far focused mainly on the authority of the state on one hand and parental autonomy on the other. In centering children and their rights, this law marks a turning point and a paradigm shift. The titles of some of its sections may serve to clarify my point. The right to personal development, the right to stability, the right to participation, the right to cultural continuity and personal identity, the right to information, the right to leisure. Another indication of the Convention's significant influence on Israeli law comes case law. First of all, a change in the language of the courts. The courts, it's only after the Convention that the courts, first of all, referred to children's rights as a new encompassing doctrine and started talking about children as rights holders. In a number of cases, the courts overturned earlier precedents in light of the Convention. I will not mention them all, but in my view, the most important ruling in this regard was the Supreme Court's decision in 2000 in which all defenses regarding corporal punishment of children were abolished. Notably, this ruling described the time after Israel ratified the Convention on the Rights of the Child and the enactment of the Basic Law on Human Dignity and Liberty as a new era in Israeli law. No doubt then, the Convention's effect on Israeli law has been no less than transformative. Nonetheless, upon a deeper scrutiny, there emerges a more complex picture. In order to attempt such examination, I chose to explore the extent to which each of the four guiding principles of the Convention, non-discrimination, the best interest of the child, the right to life, survival, and development, and the right to participation, have in fact been implemented in Israeli law. These principles were defined by the UN Committee on the Rights of the Child as a cornerstone of the Convention. They were also the backbone of our work at the Israeli Committee. And I will not do it in this order. I will start with the right to participation. I will only be discussing, due to time limits, children's right to participate not in policy matters, which is a totally different issue, but in matters affecting them. The principle of participation, I think that Israel is not a special case in this regard. The principle of participation anchored in Article 12 is is undoubtedly the one that has had the most effect on Israeli law. A series of amendments which formulate children's right to participate in court proceedings in accordance with the actual wording of Article 12 have been adopted in Israeli law. Such amendments were enacted, for example, in legislation relating to delinquent youth that I've mentioned, youth employment, and children who are witnesses in court. One of the most significant reforms in this field are the regulations on child participation in family disputes. According to these regulations, special units for child participation are to be established within the Israeli family courts. Children over the age of 6 are to be given the opportunity to participate in court proceedings, either by talking to a social worker, and we have some of the social workers working within these units here with us, or by talking to a judge directly. Ask the child to do this. Only recently, the Attorney General has issued guidelines stating that minors over the age of 12 who are candidates for deportation must be heard before decisions are made in their regard. I believe that these children should be heard at a much earlier age. But the recognition of the right to participation with regard to children who have almost no other rights, I think it speaks to the impact or the power of the right to participation in Israeli law. Significant change with regard to child participation is also evident in case law, as conveyed in the ongoing declarative recognition of children's right to participate, and in the significant rise in the rates of their actual participation in courts and administrative proceedings. These changes were at least partially accompanied by a shift in the attitudes of many practitioners as to the importance of child participation. Thus, for example, many of the social workers working within the Israeli family court system who had first shown strong reservations about the idea of child participation in divorce proceedings became actually strong supporters following their actual experience with it. And yet, the change is far from complete. One problem is that often children are still not heard. And when they are heard, there are many problems with the way they are heard. For instance, almost never do children have a feedback after participation. So nobody comes back to them and tells them, this is a decision, this is a reason, this is why you made this decision. The main difficulty, however, in my view, concerns the weight that is to be given to children's views once they are heard. Israeli case law, and in this regard, I believe that Israeli jurisprudence is not exceptional, emphasizes the right to be heard, but does not establish any guidelines on the weight that is to be accorded to their views. The scant research on this topic, including an important article by Professor Rahon, who is here with us, indicate that in practice, children's views tend to be given little weight. The second principle I would like to discuss in examining the limits of the Convention's influence is the best interest of the child as anchored in Article 3. Two main questions emerge concerning the interpretation of this principle. The first relates to the interpretation of the phrase, the child's best interest. What does it mean? What is the relationship between the child's best interest and the various rights mentioned in the CRC? The second is the weight that is to be given to the child's best interest in decisions relating to children. Due to time limits, I will address only the first question relating to the content of the best interest of the child. The UN Committee on the Rights of the Child has recurrently stressed that the CRC must be read as a whole. The child, according to this interpretation, the child's best interest is not in tension or in contrast with any specific children's rights, including children's liberties and the right to participation. In determining the best interest of the child, the various rights should be examined and balanced. This was also the approach adopted by the Israeli CRC committee. According to our recommendations, the content of the best interest of the child's principle must be redefined in light of the convention, and this is our definition, as the range of rights, needs, and interests of the child. This is our new definition, which actually tried to incorporate this new view, this new meaning of the child's best interest. The committee also recommended a checklist for examining the child's best interest. The best interest of the child's principle had been recognized as a significant principle in Israeli law long before the CRC. But the meaning given to it was vague and paternalistic and subjective. Following the convention and the committee's reports, you can actually find a significant change in the way the principle is articulated in Israeli law. Thus, for example, this new formulation of the best interest of the child as the range of rights, needs, and interests of the child has been adopted in legislation, in the Children's Foster Care Bill, in the adoption law. It is also well reflected in case law. Dozens of judicial rulings refer to the new wording in defining the best interest of the child. In the words of Judge Geisman from the Israeli Tel Aviv Family Court, and I quote, "Today, new meaning should be ascribed to the concept of the best interest of the child, shifting from the paternalistic perspective that had been at its focus to one that views the child as a whole person, as an independent and autonomous right bearer." However, unfortunately, the rhetorical endorsement of the new conceptualization of the best interest of the child's principle is only rarely reflected in the actual decisions of the courts. In most decisions, even those who mention the new formulation of the range of rights, interests, and needs of the child, the court did not examine the specific rights or refer at all to the specific rights of the child that are relevant to the case. Basically, the discussion is very similar to the discussion that we had years before. In the Israeli CRC committee, we deliberated whether we should change the name of the best interest standard or just the content or interpretation of it to reflect the new meaning, to reflect the shift of attitudes to how we make decisions about children. We decided to keep the name and only change the interpretation and the definition of how decisions should be made. We may have been wrong, as the long legacy and perhaps inertia of how courts apply the best interest standards seem to be extremely difficult to change. Children's right to life, survival, and development. The next principle I would like to examine is children's right to life, survival, and development, anchored in Article 6. I will limit myself to the right to development. The recognition of children's right to development expresses a fundamental difference between children and adults. Children are in a process of swift and very vulnerable development, which imposes special obligations on both parents and state. Signs of reference to the right to development can be found in Israeli law and case law in the wake of the convention. For instance, the Children's Foster Care Law, which I've already mentioned, defines for the first time, and I think it's very important, the right to personal development as a right of children. Relatively rare mentions of the right to development are found in a number of court decisions dealing with issues such as the justification for the state's authority to intervene in order to protect children, the prohibition of corporal punishment, and an issue that is now very topical in Israel, the need to refrain from detaining children of immigrants as it will harm their development. Nevertheless, the actual influence of this principle on Israeli law is extremely limited. Neither the legislation nor case law has translated the recognition of the right to development into specific duties of the state. When services for children are constantly being cut, the right to development does not serve as a shield for children. The implementation of the right to development is not a simple task and will require complex thinking of the scope of state obligations. It's a very recognition that this right imposes clear and new obligations on society, which Israeli law has not yet reached, could be, in my view, the key to the change that is probably the most essential in the lives of many children in Israel. And last but not least, non-discrimination. The non-discrimination principle is obviously not unique to children and applies to everyone. According to the convention, however, this principle has special features and importance when applied to children. First, the convention states that children are not to be discriminated against due to acts or characteristics of their parents or family members. Beyond this, however, ensuring children's equality imposes, according to the convention, enhanced obligations, and this is very important, on the state. The reason is that the principle of equality should be read together with the principle of development, on the assumption that discrimination against children is potentially very harmful to their development. Children who are victims of discrimination in services regarding their health, their education, or safeguarding their personal safety are children whose development could be irreversibly harmed. The principle of non-discrimination, as articulated in the convention, has been adopted in some legislation in Israel, such as the foster care bill and the municipality ordinance, which establishes special local committees on the rights of the child. And yet, its real impact on Israeli law has so far been negligible to non-existent. A review of all published Israeli case law found no mention of Article 2. Needless to say that there is no discussion of the unique importance and characteristics of non-discrimination of children. In light of the great challenges and alarming data that we're facing regarding discrimination of many groups of children, such as Arab children, Ethiopian children, children of the periphery, and many other groups of children, the Convention's lack of influence in this area is very troubling. In conclusion, any attempt to sum up the influence of the Convention on Israeli law must grapple with a complex reality. On the one hand, and it's important for me to emphasize this because we're really celebrating the Convention here today, the Convention definitely had a profound effect on Israeli law. At the same time, the limit of the Convention's transformative effect on Israeli law are quite evident. What explains these limits and what can be done to enhance its effect? I can think of three possible explanations. The first is that we're still in the middle of the change and that better implementation will just come with time. This is an optimistic explanation, perhaps an overly optimistic one. A second potential explanation for the limits of the Convention's influence would be a life cycle one. After reaching a peak in the early years, and especially after the committee's reports were published, there is a decline now, and perhaps even some withdrawal in the effect of the Convention. This theory can get anecdotal support by looking at the number of Supreme Court cases in Israel that actually mention the Convention over the years. And we can see a notable rise, really like threefold, between the years 2005 and 2007, after we filed our committee's report, and then a decline in the number of cases in which the Supreme Court mentioned the Convention. The third and last explanation focuses on the text of the Convention itself and its interpretation. The Convention presents a holistic, non-extreme approach. This approach has been the key to the Convention's success all over the world. The downside, however, has been a limited ability to mobilize perhaps more transformative reforms in some areas. What can we do? What can we do to enhance the Convention's influence? On the domestic level, we should keep the discussion going. We should constantly monitor the Convention's effect and vigorously argue for its fuller implementation. On the international level, I think that we should do exactly what we're doing here today. We should recommit constantly to the Convention, and work in order to enhance the comparative analysis of the Convention's impact in the various jurisdictions. We should learn from success stories of other countries in implementing the Convention. No less important though, we should use the comparative lens to locate and define common obstacles to the full implementation of the Convention. Such insights can assist in the already amazing work that the UN Committee on the Rights of the Child is already doing, affect its implementation, and perhaps with time, I say this very cautiously, even lead to some changes in the Convention.
Well, thank you very much, Tamara. I think we ran out of time. So,
Go for coffee and
and thank you.
thank you all the panelists.
Exactly. So